Hello, my name is Robert Goodwin, and this is Law on the Line. We are produced by the Middlesex County Bar Foundation. We're having our show now after a long hiatus that interrupted by the COVID virus, and I'm here today with our first guest of our new season of productions, and I would like to welcome to Law on the Line George Baroud. George is an attorney in New Brunswick. His office is located at 52 Patterson Street, and George is a specialist in the area of landlord-tenant law and real estate, commercial and residential. As you can guess, my topic, or our topic today, is landlord-tenant law. And I've known George for a number of years, and I look forward to our discussion about this topic and as it affects all of our listeners, or many of our listeners. At any rate, since COVID, what has happened to the landlord-tenant law in Middlesex County and statewide?
Well, first, Bob, thanks for having me. And thank you for putting on this show. I know it's such a service to the community. I know you've done it for over half a dozen years. But like the way that the Law on the Line stopped during the coronavirus, the landlord-tenant court essentially stopped. In March of 2020, cases that were pending were adjourned. They were pushed off for a month, and then 2 months, and then multiple months before the court figured out how to resume landlord-tenant matters, and they did that through an app called Zoom. Cases went virtual, and we were able to have trials. We were able to continue with landlord-tenant matters virtually. All the filings were done virtually. Everything's done now through the court website, but it's been slowly returning to in-person.
So, George, when did things with regard to landlord-tenant law, as it did in the other divisions, come to a screeching halt?
Absolutely. It came to a stop, and there was no way for a tenant to be forcibly removed from a residential rental unit in Middlesex County or throughout the state of New Jersey.
So if I were a landlord and I filed a complaint in February of 2020, and my court date now is the end of March of 2020, perhaps 4 weeks afterwards, what happened to my complaint? Where did it go, and where is it now?
There are still cases from 2020 and 2021 that are still pending in the court system. But the coronavirus really disrupted everyone. There were tenants who lost their jobs, businesses that closed. There was no money coming in. So what the court did was they stopped the eviction of tenants for fear that there could be a great number of homeless people throughout our state. But if you're thinking, wait a minute, that doesn't sound fair to the landlords and the property owners, they also stopped foreclosures. So the mortgage companies could not foreclose on the landlords or property owners, but the landlords and property owners could not evict their tenants. Everything was pretty much frozen until everything could resume.
And when did it start to resume, if you will, and return to some level of normalcy as we experienced prior to the COVID virus?
We're not there yet.
Oh.
But there was a lot of government assistance. A lot of tenants were able to find assistance through the DCA, Department of Community Affairs, state, federal, or county level programs. There's still some funding available that tenants can find to help them if they're deserving, especially if they were impacted by the coronavirus.
And this is to assist them in paying the rent to the landlord?
Yes. So many, I wouldn't say most, but many of the cases that were pending in 2020 and 21 are no longer, they didn't reach trial, but they don't need to anymore because the funds were found. Either the tenants picked up and moved on their own, or the funds were located through different assistance agencies and the landlords were made whole. But there are still cases pending, and the new cases are still delayed because of the backlog.
So If I am a landlord, for example, and I am seeking to bring an action against a tenant for non-payment of rent, as the court system or the landlord-tenant court is now structured, what is the process? What do I do as a landlord?
So the process, the coronavirus was awful. I lost 3 of my aunts to the coronavirus. I know a lot of people have had really hard times, but there was a benefit. The courts have gone online in a much more efficient, better way. So there might be a website popping up on your screen now for the courts, njcourts.gov. You can now go online, find all the forms that you need to prepare and file a complaint in the landlord-tenant court, and you can file those forms electronically. You do it all from the comfort of your home. If you are not a business entity, if you're not a corporation or an LLC, then you can represent yourself. You go right on the court's website, you look through the forms catalog, and you find the landlord-tenant link, and there's lots of helpful information in all the forms that you need. You fill out the forms, you pay the fee online, and your complaint is filed.
And that would be, for example, if a landlord were to file a complaint.
Yes.
Now, if you're a tenant and you want to respond to the complaint, what is the nature of the response, and how is that information communicated to a tenant if a complaint is filed?
It's just as easy for the tenants now. They go on to the same court website, and there's information that's helpful to the landlords, and there's information that's helpful to the tenants. But there's also, I've provided the station here today with a phone number for 2 different entities, the Middlesex County Bar Association, which the Bar Foundation helped us put on this program today. The Bar Association has a lawyer referral program. And there's the Legal Services of New Jersey. They also have assistance available to tenants where they could find free legal representation if you qualify, or you can go through the Bar Association for a referral for an attorney that you would pay to help you.
And there's also a reduced fee program that some volunteer lawyers sign up for with the Bar Association.
True, that is true.
And that would really assist the public. Mm-hmm. So if there is a complaint for eviction filed, for example, non-payment of rent, and I know there are other causes for evicting a tenant under our law. Very briefly, what are the other actions that landlords may bring against the tenant to bring an eviction against that tenant?
There are only about a dozen different reasons in the state of New Jersey that a residential tenant can be evicted. I would put 90+% of the eviction complaints to be for non-payment of rent. The other grounds would include a breach of lease. Of course, it depends on whether you have a written lease or a verbal lease. You could be breaching the lease by paying your rent late, having a pet where no pets are allowed. I'm not talking about service animals that are allowed even when pets are not. That's a whole nother topic. Mm-hmm. You could be a disorderly tenant, causing damage to the property or disturbing the peace and quiet of the neighboring tenants if it's a multifamily unit, or the neighbors if it isn't.
And I know with regard to that, and I know we're getting into a little substance, there are notice requirements that must be given to a tenant if there are reasons other than non-payment of rent. I believe it's called a notice to quit, explain that very briefly to the tenant. And is that something that's communicated in writing to the tenant, or is that or verbally?
If a property owner is filing to evict a tenant for non-payment of rent, you don't need to provide any advance notice. For any other reason, you must provide advance notice. And you often have to provide 2 different notices. The first notice being called the notice to cease, where you're telling the tenant to stop doing something wrong. For example, if they're paying late every month, you prepare the notice to cease, where you're telling them that they're paying late and that if they continue to pay late, the lease will be terminated and they'll be evicted.
And that would be something that would be spelled out specifically in the written lease between the landlord and the tenant.
Right, right. The lease can have lots of different clauses that the tenant needs to comply with, including the date the rent is due, whether pets are allowed, how many occupants are allowed to be in the property, how they're allowed to use the property. I've experienced situations where the tenants who are lucky enough to have a washer and dryer are allowing the whole neighborhood to come in and use the washer and dryer. And the tenants might be making money as a result, but the landlord's paying for the water and the electricity and the upkeep of the appliances.
So I send a notice to cease that you're using your example, somebody is misusing a piece of equipment in the apartment or the unit, and I don't cease that behavior as the tenant. What is this notice to quit?
So the notice to quit tells them very particularly that they had the notice to cease, they had the opportunity to stop doing the things that they're doing wrong, and that they hadn't. And it spells out the new violations since the notice to cease was issued. And it then tells them that the lease is terminated and they must vacate. Both of these notices are a little tricky to draft. They have to be detailed. You have to have all the facts in there so that the tenant has an opportunity to come to court and know what they're being accused of and ready to defend it. But after you send the notice to quit and you terminate the lease, if the tenant doesn't move out on the termination date, the property owner files an action to evict them.
So the notice to quit specifies a termination date for the reason specified in the notice.
Correct.
And again, this doesn't deal with non-payment of rent. So if I receive the notice to quit, I, as a tenant, do not respond, you bring that action to evict.
Right.
And you've described how you do that now online. There are many forms. I'm the tenant. How would I get that complaint? How do I know that this action has been brought against me?
One of the new things the court's asking for on the complaint is the email address of both the landlord and the tenant. That was never required before the coronavirus.
Correct.
But the notices are still being mailed to the tenant at the property address by regular and certified mail from the court. But the court will also communicate with the tenant by email. So things have become more instantaneous. There's less worry about the mail not arriving to the tenant. But they're also sending it by mail to make sure that they have the correct email address and that the tenant's getting it. So the tenant gets plenty of notice of what to do and how to appear in court.
So the tenant now, post-COVID, post-Zoom, has to appear in court.
Right.
And when the tenant appears in court, and we're talking, for example, Middlesex County, they appear in what section? Is that the landlord-tenant part of the court?
When you appear in court, so court has still been by Zoom, so you can appear from home on your smartphone or your computer, but it's going into in-person again. So you'd go to the Middlesex County Courthouse at 56 Patterson Street, assuming the case is in Middlesex County.
Of course.
As soon as you walk in, you have to go by the sheriff's officers and through the metal detector, and you could tell them you're going to landlord-tenant court. They'll let you know exactly where to go. But the notice tells you that it's courtroom 205. So you go to the second floor and you find 205 and you check in. And
we're going, that is in Middlesex County, it will be going back to in-person entirely, or will there be any other proceedings that parties and or their attorneys may appear by Zoom?
Before the coronavirus, when you filed an action to go to landlord-tenant court, you went to the landlord-tenant court in about 4 to 6 weeks. The coronavirus created this new step where there's a hearing called a case management conference. You don't see the judge. You get some of the facts set in place with the court. They go over the amount of rent due, and they get documents like the lease and other evidence before you get to trial. So the trials are going to return in person. If the case management conferences proceed, I believe they're going to continue from through Zoom in Middlesex County, but every county is going to be different.
I see. And the information that is imparted in a case management conference, to whom is that communicated?
An employee of the court. So one of the court clerks will be there, and they simply go through questions and find out where the dispute is between the landlord and tenant. Sometimes it's agreed there's a certain amount of rent due, and sometimes it's disputed that the amount of rent is not agreed upon, or there's a reason why the tenant isn't paying the rent. For example, the property isn't habitable. There's mold, or there's no heat, or there are other issues, which is why the tenant isn't paying the rent. So when it's a non-payment of rent case, the court can also direct the tenant to certain agencies that might have funds available to pay the rent for either partially or in full for the tenant, which would resolve the issue.
At the case management conference, the way it's currently constituted, is there any process for mediation at that point between the parties?
You can mediate at any time, including the day of trial. But at case management, you can mediate, and the clerk of the court will even help you fill out one of multiple settlement agreements, but there's two main consent agreements. One of them is where the tenant agrees that they're going to pay and stay. If they can't pay in full, they might come to an agreement where they pay a certain amount more than the rent every month until they're paid up.
Paying the arrears.
Yes. Mm-hmm. And the second option would be an agreement where the tenant agrees to vacate, but by a particular date. So rather than the court officer coming with the property owner and locking them out on an unknown date in the near future, they come to an agreement of perhaps lockout a month or two into the future, where they agree on the date and perhaps some payment or perhaps no payment.
I see. Now, if I am the tenant and I am raising a defense, for example, you said uninhabitable conditions, let's say mice and other vermin, lack of heat, hot water. I appear in court on a non-payment of rent application made by the landlord. How do I present that to the court, and what do I have to do to make sure that my case is heard?
The most important thing for a tenant to know is that if you're holding your rent from the landlord because of one of these allegations, habitability or mice or any of the issues, you must have the rent. If you don't go to court for 2 or 3 or 4 months, when you appear in court, you should have all of that rent ready to pay, because you might be paying it to the landlord if the judge doesn't agree with your argument, or you might be paying it to the court if the judge does agree with your argument. Then you'll have a hearing, and you could prove your case by showing the letters that you've written to the property owner and the photos or videos that you've taken to show the condition.
And at that point, the judge will make a decision whether or not your defense is successful. Would the judge at that point abate the rent or reduce the rent, or is there any kind of remedy of that nature?
They can. The judge has the power to say that the back rent that's due should be reduced in favor of the tenant if they were living in certain conditions. But those conditions generally have to be pretty serious. Some tenants come to court and think that chipping paint or a crack in a window pane entitles them to pay no rent. But the lack of heat or the lack of running water are the types of serious rent-reducing arguments, more so than a nuisance. And so the amount the judge reduces the rent, if at all, will depend on the situation and how long it went on for.
So a tenant has to be aware of the fact that if they do come to court and they are alleging a defective condition, if you will, something that would impair the habitability of the unit, they have to have the rent nonetheless available either for the court.
Absolutely. And that's one of the difficulties some tenants will face, is they'll start to put the money aside waiting for court, and then they'll find a need for it, whether the car breaks down or they have some other medical need, emergency comes up, and then they spend the money. When they show up in court, they no longer can argue their defense when they don't have the funds.
And with whom are the funds deposited, and what is the mechanism for that? If I am the tenant now and I am raising this defense, where do I put the money?
The money can be paid into the court. The court will provide the instructions. Also, the landlord and the tenant can come to an agreement where the monies are paid to one of the attorneys, if there are attorneys involved, or to the landlord, especially if the tenant's not moving out at any time, because he's still secure, the tenant's secure, and the landlord will make these repairs, or else the tenant won't pay future rent.
I see. Is there a time frame under which the tenant must pay the rent?
Yes. If the property owner's already filed an action against you, you need to have that money on the day of court. The court may give you an extra day to come and post it with the court, but on the day of court, you should have it. But more importantly, there's also a time frame for the property owner. So boilers break. The heat could break in my own home. There's no obligation for the landlord to never have an uninhabitable condition. They just need to reasonably repair it, reasonably within a reasonable amount of time. If the boiler breaks, they need to call somebody to come and make the repair. If the person can't show up till the next day, depending on the time and the day, that's reasonable. So the landlord, as long as the landlord acts reasonably in taking care of curing violations, it's the tenant. Everybody needs to be reasonable. The tenant can't say, you can't send somebody to repair the boiler if the boiler's broken Monday through Friday, 9 to 5, because I'm out at work. You can't come into the property when I'm not home. That's when these service people work. So the landlord and the tenant need to cooperate. They need to be reasonable.
And consequently, then the tenant can't say that the landlord didn't repair or remedy the situation and then justifying a withholding of the rent.
Of course, they can say it.
Oh, of course.
So the landlord needs to be ready with, I've contacted the tenant. How did I contact the tenant? A text or email or letter, and I said, I've given you all these different days and times when I wanted to come, and you responded, no, you can't come.
And this is part of the evidence that each side would present in a court before a judge if it were to go to that extent. Either to prove the case that the eviction is appropriate or to defend against the failure to attend to a repair.
Correct. And if you're representing yourself, don't get too worried about the fact that I'm saying evidence or discovery or that they're big words. You're basically bringing your lease. You're bringing your proof of payment, copies of bounced checks. You're bringing photographs or videos. That's what the judge will be looking at. What you do want to know is you need to hand these things to the court if you're there in person. They're not going to look at a photograph on your cell phone. It needs to be printed out. If you have a lease, you should make a copy of the lease. You should have it ready to hand to the court.
When we're referring to leases, are we only referring to written leases with specific terms, or is a tenancy created with a handshake and we have a tenancy? Or you could come into the apartment and your rent is X?
The answer is both and a whole lot more.
Okay.
So you could have a property owner could have an empty apartment, and somebody could break into that apartment and say, I needed an apartment, so I'm here now. Here's the rent. If the landlord takes the rent and starts working with them, that's your tenant. You now have created a landlord-tenant situation. You could do it by illegal entry, you can do it by a handshake, you can do it by a written lease agreement, but of course a written agreement is best. If you don't have a written agreement, there could be a dispute later about whether you were allowed to smoke in the property, whether you're allowed to have a pet, how much the rent is, who pays the water or the utilities. All of those items get ironed out in a written agreement.
Or how many occupants, for example, I guess.
Absolutely. The coronavirus, with the loss of jobs, the loss of income, the pressure put on a lot of tenants, created a lot more overcrowding than I have seen prior to the coronavirus. So sadly, people, rather than be homeless, were squeezing in together, creating overcrowding conditions, which were even dangerous.
So, not using the extreme example of entering an apartment illegally and say to the landlord, here's money for rent, and he accepts it, not creating a lease. We enter into a lease with a handshake. What is the term of that lease? Or if I had a written lease for a term, and the lease expires and the landlord doesn't do anything, but I'm still there. What are the permutations?
Most of the
those?
residential leases that I see have a written term of 1 year.
Mm-hmm.
When
Yes.
those leases end, if the lease doesn't say otherwise, that tenant becomes a month-to-month lease in the state of New
You
Jersey.
say otherwise. What could the lease say that is otherwise?
The lease could say that it automatically renews on a 1-year basis.
Oh, okay. So now what do you have? A 1-year lease.
Of course.
And go ahead. And so if it doesn't say otherwise, we're on a
We were on a month-to-month basis. So the tenant would then be able to stay in that particular rental unit indefinitely, month to month.
and indefinitely means indefinitely.
Absolutely.
I want to end the indefiniteness of that. I am the landlord. What do I have to do if it's a month-to-month tenancy?
Again, in the state of New Jersey, there's only about a dozen reasons why you can evict a tenant. And just because the lease ends is not one of the reasons. If a tenant dies, that's not a reason for a lease to terminate. One of the reasons a lease could terminate is if the property owner wants to live in that unit. If it's a 1 or 2 family house, the property owner could say, I want to live there, so they'd give the proper notice, the right amount of time, and then the tenant would have to move. The landlord...
Let me go back to the death.
Yeah.
Tenant dies. What happens to the tenancy? What may the landlord do or not do, as the case may be?
So I've said this earlier, and I want to repeat it because it is one of the most important things in New Jersey tenancy law. The landlord can never go and lock out the tenant themselves. There's no self-help eviction.
And I'm dead.
In order for the landlord to evict your estate,
Ah, okay, my estate.
you or your estate or your belongings, a landlord needs to go to landlord-tenant court or one of the other courts, slight differences I could get into later, get an order, get a warrant of removal, and then bring the court officer to do the lockout.
And the court officer back in the day used to be the constable, now it's a court officer, and he actually effectuates the lockout.
Correct. The landlord can never do the lockout themselves, never take a tenant's belongings and just put it at the curb, never change the locks without that court order.
And if you're close to that point in time where you're going to be locked out, do you get notice of the time and date of the lockout?
Yes. You get notice of the court action pending. You get notice of the trial date. You either appear at the trial date or you don't. But then when the property owner gets the order, something's issued called a warrant of removal. That notice gets posted on your door. It says, we're coming to lock you out in 3 business days. So the tenant has more notice.
Is there anything that I can do as a tenant to stay or stop the warrant of removal?
Absolutely. One thing that you can do, which is new since the coronavirus, is even after the landlord's won in court, if they've won for non-payment of rent, you can pay all the money after they've won within a certain short period, and the judgment will go away.
Good.
Another thing you can do is you could contact legal services or the court, and they have other ways to extend your stay or oppose it.
Well, I just got word that we have run out of time.
But I have so much more to say.
I know you have pages and pages of notes, and I have a few pages left too, but so is the facts of law on the line. We're allotted a certain amount of time, but it's always a pleasure to talk to you and to other guests with our allotted time, and it's been edifying. I've learned a lot about post-COVID landlord-tenant law, and I wish to continue this conversation, perhaps in a more substantive way with regard to commercial leases and that whole realm that we really didn't discuss.
It's different. Commercial, residential, owner-occupied properties are different. There's a lot of differences. But thank you for having me today.
And I thank you for being our guest. This is Robert Goodwin for Law on the Line, and I thank you for listening.